What if I told you that there's a government form that lets you legally shift liability and most people have no idea it even exists? In this video, I'm going to show you how IRS Form 56 can be used to challenge debts, shift fiduciary liability, and exit contracts you never knowingly agreed to. Now, I've studied consumer law, trust law, IRS administrative processes, and I'm here to expose a strategy most lawyers and accountants won't touch. Before we dive into this video, thank you guys for watching this video. Welcome to the video. We got a lot to talk about, man. So make sure you stick all the way to the end. If you're brand new, hit the like button, hit the subscribe button so that we can keep dropping more game like this. Congrats, we just hit 30,000 subscribers on YouTube. I need to get me a soundboard, so just imagine somebody clapping or something like that, man. W's to you guys, man. Also, this is not financial advice. This is not legal advice. Make sure you do your due diligence no matter what we talk about on this channel. You dig what I'm saying? This is all for educational purposes only. I'm not perfect, so I'm not going based off of you guys trusting me. I want you guys to just go find the truth. I'm bringing awareness out there because most people will make this stuff sound so mystical, and a lot of people don't believe it, okay? And I don't care if you believe me. You know what I mean? I'm just going to put the information out there, and the people that are on the right frequency are going to take this and say, you know what, this actually helped me on my journey. I have plenty of people that are able to get results, and they just watch my YouTube videos, okay? So if you're willing to tap in to the information, you dig what I'm saying, after you watch the video, or even dive deeper and maybe watch more videos than just saying, hey, look, I was just so interested in the Form 56 because that's where I'm at energetically. I think that the Form 56 is going to be able to be that magic potion. No, that's just a part of the process. You don't have to use a Form 56 to discharge debt, okay? But if you use this in combination with your process, then it could be very helpful. All right. So again, I'm not at all putting this out there as this is something that's going to literally start discharging your debt right away. This is me talking about Form 56 and the aspect of helping you to be able to execute these processes much better. OK, so thank you guys for tapping in. All right. Now, this will be more of a part 1 to the Form 56. And I'll do a part 2 if we can get this video to 300 likes. Okay, so let's tap in. What we're going to be talking about is what the Form 56 is. For those of you guys who don't know, just break that down in layman's terms as best as I can. We're going to talk about why this matters, how to properly use it to execute, how to fill it out strategically and not, a lot of people just say, oh, it's one way to do it. We're going to talk about the pros and cons of one way to do the Form 56 that makes you the fiduciary and the other way of you revoking your fiduciary access, how it ties the debt discharge, and we're going to talk about the things to look out for, the red flags, and what strategy to take. So make sure you stay all the way to the end because we got a lot to talk about. All right. So let's dive straight in. The first thing I want to talk about is the Form 56. Okay. So the Form 56, okay, it's 2 parts of the Form 56. Obviously, there's part 1, which is the aspect of, the identification, the purpose, and then part 2 is determining whether you're looking to revoke or, be the fiduciary, if that makes sense. So let's just talk about what it is, okay? The Form 56 is notice concerning fiduciary relationships. So when you think of the Form 56 would determine, well, let's just talk about what a fiduciary is. A fiduciary is typically the person that manages the money in a trust or manages the paperwork as regards to the finances in a sense, right? If I pull up fiduciary, right, it'll say involving trust, especially when regards to the relationship between a trustee and a beneficiary, held or given in a trust, financed depending on its value on securities. It says a trustee, okay? When you think of trustee, I mean, they're going to literally, why would they? It's almost like defining trustee as a fiduciary. I guess Google's not very helpful, but the person in the trustee is the one who kind of just manages everything in the trust, if that makes sense. There's the grantor creates the trust, and then the trustee is the one that manages the trust. Typically is not the grantor, okay? And then when we talk about the beneficiary, the person that's the beneficiary just benefits from the trust. He doesn't control, he doesn't manage, he doesn't do anything within the trust but accepts all the benefit. So that's what a fiduciary is. So then when we go to the aspect of what the Form 56 is for, the Form 56 is used to notify the IRS that a fiduciary relationship exists or that you are resigning from it. So it's two purposes of the Form 56. One is for the purpose of making you or appointing someone as a fiduciary, or this is something that you would inherently use for your trustee or a third party company if you want them to manage your trust or a trust, right? Or if you were particularly taking yourself out the equation, okay? And there's pros and cons of being either one, and we're gonna talk about that later on in this video. Now, a fiduciary also means someone who is responsible for managing someone else's financial affairs, and hence they often assume you as the fiduciary of the straw man. Now, not only that, right, but anybody that you put in an application with, whether it is a loan or a credit card, whatever the case may be, that right there essentially makes them a fiduciary as well, okay? You can have multiple fiduciaries, but what happens is when you create your own Form 56 and you actually appoint one, right, yourself, and then also at the same time, or if you appoint yourself as the fiduciary, then it revokes all access for anybody else being a fiduciary, especially when you fill out this form, okay? Most people don't realize that by staying silent, they agreed to be the financial representative of a corporate entity created in their name. So there's the aspect of you're automatically being assumed as the fiduciary instead of you kind of just making that choice yourself. And that's what the Form 56 is for, okay? Now, here's why this matters when it comes to debt. Number one, debt is often attached to the all caps legal name, okay? Your all caps name is a trust, okay? It's an estate, it's an entity. You dig what I'm saying? So it's not that you are that, you are responsible for it. That makes sense, okay? Now, here's what the Form 56 lets you do. The Form 56 accepts the fiduciary role as trustee for entity privately, and then also at the same time you can use the Form 56 to resign from the role and notify the IRS that you're no longer responsible, okay? And someone will say, well, you know, okay, if I decide that I'm no longer responsible, do I just not have to pay the debt? No, not necessarily, okay? You can use this, you can take yourself from that, but you then will have to appoint somebody as a trustee or as a fiduciary as it pertains to your trust, okay? So you can name another trustee or indicate that the fiduciary relationship has ended, okay? And another thing to understand is that if you didn't knowingly create this relationship, you have the right to resign from it and shift the burden back to its origin, all right? Here's the other aspect on how to properly fill it out strategically, okay? When you are filling this out, okay, when you go to the identification part, the first part, you're putting your all caps name, all right? Name of the person of whom you are acting, okay? All the identifying information, the fiduciary's name, okay? So you want to put your name, okay? Or whoever's name that you want to resign, all right? Or make the fiduciary. Address, okay? Fiduciary of interstate estate or other, okay? You fill all of this out according to your situation. But I want to scroll down to part 2, and this is where you kind of explain whether you're assuming, resigning, or terminating your fiduciary relationship, okay? So when we go down to, there's total revocation or termination, if you're just totally trying to revoke it, or on 7, if you're doing like a partial revocation where you would essentially like specify how you want this to, how you want the partnership or relationship to go, okay? These are the key parts, or on the aspect if you're looking to substitute the fiduciary, you can look at box 8 as well, okay? You choose either one of these boxes, but whether you're, I think that for one, and I'm saying I think because again, I don't want to push one to just go one route. I think that you definitely, I think that box 7 is probably going to be more, you'll have a little bit more freedom of what you decide to do, but it says it right there, okay? Whatever you determine. And then part 3 indicates the relationship, whether you're going to be the trustee, the executor, etc. All right. And another thing that you can do is when you fill out a Form 56, you can attach things like sending a letter explaining exactly what it is, and then also like an affidavit of truth. It's optional, but it can just enhance the Form 56 and make it a little bit more powerful. Now remember, this is all just putting out public notice, okay? If you put out public notice that either you are resigning from the fiduciary responsibility or appointing someone else, this is something that you can use as evidence if a company tries to say, well, you are responsible for the debt. If you're not the fiduciary, then technically, what do they want you to do? You get what I'm saying? Like, they should be talking to your fiduciary, all right? Because if you revoke yourself as a fiduciary, then the next person that kind of comes into play will be somebody that you put in that application towards. You get what I'm saying? And this is how you essentially shift the burden of proof or put it back on the creditors. Because if you're not the fiduciary, then who is? Who would be managing that? So when you do fill this out, you send it to the IRS certified. It gets notated, it gets put on record. You want to create copies, and this is something you can send to all the parties involved. All right. Now, when it's done properly, the Form 56 can be used in tandem with conditional acceptance or debt validation to expose fraud as it pertains to debt. Okay. Now, here's how it ties to debt discharge. Once you are no longer the fiduciary, you are no longer the liable party, your person, okay? Doesn't say that your all caps name wouldn't still be liable in a sense, but in essence, your natural person wouldn't be if you resign from the fiduciary role. Now, you can issue a notice of tender or administrative discharge as a third-party agent or trustee. And this is when your private trust can come into play, where now your trust can now be the fiduciary and your trust can now do the communication, okay? You can just play your role as the grantor or the beneficiary, truly. Now, this positions you to not be a debtor, but more of a beneficiary, okay? You can combine with things like the power of attorney, which is Form 2848, to appoint a fiduciary. And you can combine this with the 1099A, C, OID to reflect abandonment or discharge. Okay. Again, it all dives back into still communicating and kind of, structuring everything a little bit differently. So it isn't that you are directly communicating. Do you see how when you are not directly communicating with debt collector, between like you and the debt collector, and you separate yourself from that communication process, that right there actually gives you a little bit more shield, more power. It makes things more, how should I say, it gives you more distance. Okay. And I talked about this in my previous videos. Okay. And then some people look at this as tax evasion, but it's really more like a lawful reclassification. Okay. So I want to talk about the pros and cons when you are the fiduciary and when you are not the fiduciary, because I don't want people to get confused and say, should I make myself the fiduciary or not? Okay. When you are the fiduciary, whether you're the trustor or the executor, okay, the trustee, you are the one in control. So if you're planning to essentially do all your communications, you're going to plan to do all the discharging and things of that nature, then you want to make yourself the fiduciary, okay? But I'll tell you a strategic way to do it so that you still kind of have your legal distance. Here's the pros. You can actually act on behalf of the entity, your straw man or all caps name. So when you file the Form 56 as a fiduciary, you can have control over it, but you still have to take responsibility, if that makes sense. You still have to do the work. All right. And you still have to do the work either way. We're about to talk about that in a second. So as the fiduciary, you have a right to discharge your own debt. This is why even now in the position that you're in as the debtor, you can act as the fiduciary or just be the representative to your straw man and do all the discharging yourself. Okay. You don't have to have the private trust. You don't have to have all of that. However, if you do have a private trust, then it does become you know, it does give you that distance, because you can still have a private trust, appoint somebody as a trustee, and that right there, you know what I mean, can and you can still like do the work, but that's going to be in the second part. So you can do things like communicate about 1099As, 1099Cs, right? You can use things like conditional acceptance, right? You can use notice of tender and or private remittance under if you are the fiduciary. You can also use trust or entities, right? So if you're the fiduciary for a trust, you can assign or discharge debt with that trust structure, all right? So if you have your own trust, you can make the trust the fiduciary, all right? Not like your natural person. Now here's the cons. Obviously, you're going to have liability. Okay, if you're acting as a fiduciary and don't assert your rights properly, you may be assumed liable for the taxes, debts, or contracts. And number two, presumed debtor role. Without clarity, courts or creditors will assume you are financially responsible. So again, this always boils down to the communication aspect. I think people think that, okay, if I fill out this form, I fill out that form, then I will be, you know, my liabilities will be gone. Just because I filled out this form 56, I feel like people talk to me all the time and say, hey, look, what do you know about the form 56 and this, that, and the third, as if like that right there is like, oh, this is going to discharge your debt. No, this is just reclassifying and making discharging debt, you know, it gives you a different positioning when it comes to discharging debt. Okay, so being a fiduciary equals power with responsibility. You can handle remedies, but you need to act lawfully and strategically. This is why you have to understand the law. So I speak from both perspectives. Now let's talk about the second perspective. When you are not the fiduciary, you separate yourself from the legal fiction or entity. Okay, here are the pros. No presumed liability. You can make it clear that you are not responsible for the straw man's debts or taxes. Number two, you can act as the beneficiary and you can position yourself to receive the benefits from the trust and entity without being on the hook. And then number three, you have more privacy when you are not the fiduciary. Not being a fiduciary can add a separation between you and public liabilities. Okay, so here are the cons to not being a fiduciary. You are in less control. Okay, you may not have legal standing to file discharges, issue remittance, or take action on behalf of the entity unless you assign another fiduciary. And then number two, you need a third party. You have to appoint someone or something like an LLC as a fiduciary if you want to, LLC or a trust, if you want the benefits without the liability. So if you decide not to be the fiduciary, you have to appoint someone, especially if you're going to communicate about debts. Okay. And here's the aspect of when you're not being a fiduciary, yes, it's less risk, but you have less control. Okay. You must rely on the entity fiduciary to handle the remedy on your behalf. So here's a strategic move. Many people in the debt discharge or private trust space, they'll do things like resign as a fiduciary of the straw man, legal name using a Form 56, assign a fiduciary to a private trust or an LLC, and act as a beneficiary and direct the process without being liable. So here's the key word: direct the process. Making yourself not the fiduciary and then appointing someone, but still handling the direction, because you can appoint anybody that you trust, right? That's willing to sign those forms, put their name on the paper. You can directly put them in that position. Now, again, they still have the control in a sense, but I mean, if you know what you're doing, you can just kind of do your part, but make sure it's not going through you. Make sure your name is not attached to those debts or those forms and communication with them. It could be John Doe, your cousin, you know what I mean, a lawyer, an attorney, a consultant, somebody like that can submit the paper on your behalf, right? Create that legal distance. There are people out there that do it. Okay. Family member. But I always tell you this, you know, you got to give them an incentive. If it's going to be a family member, then make sure you aren't like truly making them like, you know, you just need somebody competent enough to submit the papers and this, that, and the third and follow your direction. If you decide to get an attorney or lawyer, someone who understands what your goals are and they're going to back you up and not try to just do their own agenda, but you're going to have to pay, obviously. All right. So I do have this chart here. Okay. See if I can zoom this in. Okay. So So if you are the fiduciary, okay, you can act on behalf of the trust or entity. And I'll put this in the complete debt guide so anybody can view this. If you have the complete debt guide, it will be uploaded this week. Liability high, presumed liable for debts if you are the fiduciary, or taxes if not rebutted. Keyword is rebutted. Yes, can file 1099A, C, Form 56, remittance vouchers, etc. Low, privacy, more public exposure. Use in a truck structure, directly assign or discharge debt via trust or contract. No need for a third party, you are the acting authority. Maintain control, but must assert right using the UCC and IRS form. So if you're going to do everything yourself, become your own fiduciary. Okay, so you can do that, but you're still liable for everything. Then also in the same time, if you're not the fiduciary, you have low control. So you must assign the authority to another party or entity, right? Liability is low, which reduce the risk of assumed liability. So they won't assume that you owe a debt or whatever the case may be. They're just going to say, you know what, the fiduciary is supposed to handle this. Number 3, standing to file discharges, no, but must authorize the trustee or fiduciary to act, okay? So given the fact that you can authorize a trustee, if it's somebody that's good, somebody that you trust, somebody that's going to follow your direction, then you still, in essence, can file discharges, if that makes sense. I mean, you could do the work and hand it to them to file it on your behalf. Privacy high, more separation from the legal fiction. Number 6, using the trust structure, using LLC or another trustee to handle debt discharge. Need for a third party, yes. You'll need a fiduciary like an LLC or a third party trustee. And then common strategy, resign as the fiduciary via Form 56 and act as the beneficiary or director. Okay? So there's the chart right here. Y'all can take a picture, screenshot, or whatever the case may be. But when you're looking at, the pros and cons, you can do either one. Some people think that they have to do it this way. You don't have to. And then there's some people who are only taught to do it this way. You get what I'm saying? Or is moving like this, but they're trying to, have these boxes, right? Some people want the control, but they don't want liability, right? Some people want to file the 1099-C on themselves, but they'll do something like revoke themselves as the fiduciary. Some people want to be more separated, but they want to, like be able to do the paperwork and this, that, and the third. Some people don't know how to set up a trustee, or know how to appoint a trustee or create a trust or have a proper structure when it comes to a trust, right? Some people want to do all the trust and private and stuff, but still want to have authority and still be able to control. Mind you, if you decide to not be the one in control, then you can't really speak for yourself, if that makes sense. You know what I'm saying? The trustee kind of has to do it for you. Yes, it'll create that separation, but you're going to have less control. So you have to decide, do I want less control and someone else do it? Remember, that's something that you're going to have to, especially when you're just starting out. Obviously, the wealthy people are able to do things like not be the fiduciary because they can hire somebody that's very competent in this and they really can be hands off, right? But for someone like yourself who may not be there, and there are people who watch me and may be wealthy and all that and say, okay, but I can go this route, right? They have the money to set up a trust and appoint a trustee, someone who is competent. They have good people around them, right? Some people are going to choose not being a fiduciary, but for most of us out there, you might want to be your own fiduciary, okay? So that you can have high control, but you still keep the liability, and not the liability of paying the debt, but the liability of performing on the debt. I hope you guys are gathering that, okay? So to pretty much wrap up, okay? It is not magic, all right? You fill out this form. Just because you fill out a form, just because you start discharging debt, whatever the case may be, or you have the ability to do this, it doesn't mean that, you don't have to go through the administrative process. This is why I talk about this very deeply. No matter what I'm talking about on this channel, I'm going to tell you that they have to understand how to send a conditional acceptance, conditional offer, understand what a tender is, understand how to communicate with a debt collector using the Fair Debt Collection Practices Act, understand the Truth in Lending Act and what disclosures are supposed to be entitled to you, understanding how to shift the burden of proof through communication through paperwork, Understanding that if they ignore you, you send a letter about them ignoring you, let them know that they have violated you and it's a dishonor. Give them a second opportunity. Understanding how to have them defaults where you created your own remedy privately, so that now when you go to court, it's not about you, trying to communicate it in court. You already have the paper trail. You already showed that, hey, I've done the private process and I attempt to get my remedy privately, and they decided to dishonor me. They decided to act like I had no voice. Okay. And so boom, this is why I have the evidence right here. And you could do it, or you can have a fiduciary do it. You can appoint someone else. You can still do it and make sure that they are the ones that file it on your behalf. Okay. You can be the direction, or you can actually be the fiduciary, whatever the case may be. No, you don't have to be private. Okay. And no, you don't have to do it in your name. You get what I'm saying? Either way, if you know how you're supposed to maneuver at whatever form or whatever position you decide to take, you're still going to be able to maneuver properly, because it's not even about like what position you're in. It's about the process. Okay. And taking responsibility for the process, whether you're going to pay your debt or whether you're going to communicate and perform on your debt. Either way, there's nothing that I'm going to say that is going to be a magic potion or lotion that, hey, if I fill out this form and that form, I will not have to pay my bill, and I can complain about it and I can express myself about it. Okay? So you must understand how to use these things in good faith and move in good faith. As long as you're moving in good faith, they cannot, take advantage of you. Okay, you can point out and highlight that you were moving in good faith, because they'll try to say that you didn't move in good faith by not going based off of what you agreed to. Okay. Number 3, make sure you keep copies of everything. When you send your letters, make sure you have a copy and you put it in a safe place. All right. That is going to be your main tool for winning, is having the paper trail. Use it as a part of a full discharge process, not by itself. The Form 56 is not something done by itself. That's why I explained it on this video, that it only shifts the role of what role you're going to play in the debt discharge process. And that's more of a public notice. But this all could be communicated in a letter too. Okay? And lastly, consider using a trust to issue these filings for further separation. So you can do the paperwork, but if you put it through a trust or a trustee, right, it gives you that separation. Okay. Better yet, if you do find someone that is willing to do it for you, some people say will say, hey, look, Nick, can you be my trustee? Whatever the case may be. I will say, no, right now I'm not trying to do that. Okay. This is why I teach people how to do it themselves. They can appoint whoever they want to appoint. Okay? I ain't trying to be tied up to y'all BS. All right? Trust me. Take responsibility. Okay? And this is why I'm willing to give the game away for free. All right? Because I realize that, hey, look, maybe right now, in the position I'm in right now, I don't inherently want to do it for people, but I will definitely teach people for free. Okay. And if one says, hey, can you write the letters and this, that, and the third? Yes, we can definitely work out an agreement, whatever the case may be. But you're still going to have to do it. All right. So you don't want them to operate on assumptions. The moment you revoke those assumptions, you take back control. You never want them to assume anything. You want to kind of put out in the atmosphere, in the public, who you are, because that is going to help you in the debt discharge process. So most people go their whole lives paying off debt they never owed, simply because they never questioned the role that they were placed in. So if you got all the way to the end, make sure to like, make sure to subscribe, make sure to hit the post notification. You're looking to tap in and get things like templates, some type of toolkit about how to discharge debt, understand a step-by-step process of discharging debt. I have forms, I have papers, I have written documentation, but also at the same time, I have course instruction on how to be able to communicate with a debt collector using the administrative process in the Complete Debt Guide down below. Okay. If you get to Complete Debt Guide, you become an affiliate. So if you say, hey, this is great information, you can refer it to other people and get 80% commission. Lastly, if you want to work with me one-on-one, not concerning me being your trustee, me being a fiduciary for you, you're looking to fix your credit, get funding, and start a business, especially in the credit repair space, tap in with me on a one-on-one tip. Okay. Also, follow me on Instagram at biz.nick. Tap in on Twitch at biz_nick. You dig what I'm saying? And then lastly, you know, if you've ever heard of the Form 56, let me know how you guys use it. Okay? Let me know if everything that I'm talking about is hitting the nail on the head. You know, tap in with me in the chat down below. Remember to like, subscribe, turn on the post notifications. You dig me? Because we're talking about things that people are afraid to talk about, won't really break down, simple. And, you know, let me know what else you guys want to learn. If you've gotten this far, comment the word discharge, and I'll see you in the next one.